All rise. All persons having business before the Honorable Associated Judges now residing over the District of Columbia Court of Appeals draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have one case on this morning's special sitting calendar, and it is RALSTON PEYTON versus United States, 23 CO 233.
Good morning, Your Honor. May it please the court, Daniel Godin on behalf of Mr. Peyton. If I may, I'd like to reserve 2 minutes for rebuttal. So 24-531-07A2, which for everyone's convenience, I'm going to suggest we just refer to it today as A2. A2 permits the month-long detention of a person without any standard, without any findings, and without any procedures. For those reasons, we think it's unconstitutional on its face. I actually want to begin today by saying why the court can't save the statute by reading standards and procedures, constitutionally required standards and procedures into it. And we have the whole sort of Conley-Tilley argument, which is this is sort of beyond the judicial role to read substantive standards into a statute. But I want to circle back to that because I want to focus on why this statute itself tells us that we can't read those requirements into it. Because the government's proposal is, to the extent it's constitutionally required, just say the judge has to make a finding of dangerousness. But reading a dangerousness finding requirement into the statute would produce an unreasonable result, because it's important to remember the options the judge has under A2 is not detain or release, it's detain or detain. So to read a dangerousness finding into the statute would be to say the judge needs to find that the person is dangerous, because if they're dangerous, they would detain them. But also if they're not dangerous, they would detain them. And what would happen is if the judge at the A2 hearing were to make a finding, I think this person is clearly not dangerous and they should be released immediately. So I'm going to order that you go back to inpatient hospitalization at St. Elizabeth's. And at that point, you can request another hearing within 24 hours, at which your dangerousness will again be assessed. And in Macklin, the court said the idea of having 2 separate substantively identical full evidentiary hearings that might occur quite closely in time was implausible and unreasonable. And that's exactly the sort of result that the court would have to read.
Counsel, I don't mean to divert you, but I do feel like we need to get back into the statute that Judge McLeese and I know and love. And I just feel like we've skipped over a step perhaps in the introduction that you've just given, because A2, it seems to me, gives this predicate choice of, is the criminal court, I mean, before we even get to continued treatment, there's the choice of whether the criminal court is deciding to order anything at all, right? Doesn't that need to be examined? I mean, why would the court decide to order anything at all versus saying, okay, I'll let the experts deal with this individual? That's sort of what I'm struggling with. What's the court's interest in a criminal case in ordering continued treatment that heretofore has been devoted to restoring someone to competency? That seems to be a decision point. Am I missing something, or am I making any sense?
Okay, so I guess we only get to A2 if the criminal court has already ordered the 30 days of extended treatment under 24-531-06C4. And then assuming if the civil commitment petition has not been filed, the judge's options at that point either can grant a 5-day continuance or release the person. And again, releasing the person actually means they're held for up to 48 hours.
If they're an inpatient cut, right? They could be an outpatient competency restoration treatment.
I guess that's
Theoretically.
theoretically
Right.
possible. In which case, and I'm not sure we need to get into this, but there's a whole host of questions about what it would mean for a judge to order continued treatment of an outpatient competency restoree, because the only treatment for an outpatient competency restoree person is receiving is treatment for competency restoration, which after the Jackson finding is no longer a legitimate basis for treatment. So the judge wouldn't really have a legitimate basis to be saying, even though competency restoration is off the table, I'm going to order continued competency restoration treatment.
Right, unless you accepted the government, the district in the United States' argument that there's some other interest in providing mental health services to the person who's outpatient, but has been Jacksoned. Right, because that's the only way that someone who's outpatient could be directed to continue outpatient, right? Because C1 only applies to the person who's inpatient.
Right, but as we point out in our reply, there is a constitutionally protected liberty interest in not receiving unwanted medical treatment. And the only way you can force a person who's mentally ill to receive unwanted medical treatment is competency restoration or dangerousness. So if the judge is going to say, I can't order further competency restoration because it's no longer reasonably related to the purpose of competency restoration by definition under Jackson. But I find that you are dangerous without further outpatient treatment, so I'm going to order outpatient treatment on that basis. I mean, that would satisfy the compelling interest narrowly tailored standard. Nothing in this statute speaks to those issues, and under due process, we think there would have to be an evidentiary hearing, which this statute does not allow for.
Can I ask you to wind back the tape even a little further to a part that you were talking about a minute ago, which is 06C4.
Yeah.
Which seems to say, again, in a standardless way, without any findings,
Right.
that a judge who's made a determination that a defendant is incompetent and unlikely to regain can just be held for 30 days in inpatient for treatment pursuant to 53105, which is competency treatment.
Right.
That seems pretty puzzling in a variety of respects. First of all, it seems odd to be directing competency treatment for someone you just found that is not likely to be of any use. But it also seems that the logic of your argument would be that that's just not a constitutional provision itself, because what's the justification in the absence of findings that won't necessarily have been made with respect to a Jackson defendant to send somebody off for 30 days, even if you leave aside the problem of treatment pursuant to, which seems competency focused.
Yeah.
It just seems like the logic of your argument is that that provision itself is not valid. What's the legitimacy of that provision? Do you agree that the logic of your argument is that that provision itself is invalid? And if not, why not?
Well, since obviously we haven't challenged that statute, so I think the most I could say is obviously, for the reasons you just said, the arguments we're making in this case would bear on the constitutionality of that section, but that section is also different. It's strictly limited to 30 days with maybe like a little bit of small wiggle room at the end there. Whereas the the A2 is, well, it's technically not indefinite. It's not fixed. It can extend for months and months and months. And I'm sure if this court were to agree with us that A2 is unconstitutional, I'm sure the government would argue, well, C4, 06C4 is different because it's limited to 30 days. And, you know, there might be a distinction to be made. I'm not saying there is, I'm just saying that statute's not before the court, but I certainly agree with you that some of the arguments we're making would bear on the constitutionality of that other provision, but they don't necessarily sink it if the court agrees with us.
Can I ask you, in discussing the facial invalidity aspect of the case, if a little in passing thus far, you use the description of reading something in, which is somewhat ambiguous description. And there is one way of dealing with alleged constitutional difficulties is to construe a statute as kind of interpret it through doctrines of avoidance. And that is most naturally thought of as reading something in that somewhat metaphorical use of the phrase. But a different concept, which maybe could be viewed as reading things in or fixing things or other metaphorical ideas, is simply to say, look, there's a statute here. Leave aside whether it's facially invalid. It's being applied in a particular context on a particular record. We see a constitutional defect. That statute has been unconstitutionally applied, and then you're not fixing anything or reading anything in. You're just saying someone has brought a case to you. It is on a record, and the record doesn't support what you would need. And so, what's the impediment to, for example, if the court were persuaded by your point that the further inpatient treatment purportedly authorized under C2 is invalid at a minimum in the absence of a current finding of dangerous to self or others. What's the impediment for saying that's the statute is unconstitutional as applied to such a person? That's not reading anything in. That's just saying there's a record. Someone's trying to, assert authority to do a thing, and the record doesn't support it. Not necessarily at the end of the whole topic, because other issues might arise, but that's enough. So I just am interested in the kind of idea of reading things in.
So there are all sorts of situations in which it's consistent with the judicial role to sort of read things into a statute. Like, for example, mens rea requirements. Conley talks about that. They say, it's totally normal when a criminal statute is silent on mens rea, we read that in. I think other cases will talk about like procedural requirements, like burdens of proof and things like that. If a statute is silent on the burden of proof and there's some constitutionally mandated a burden of proof, we just read that burden of proof.
Again, I get a little, because I view the phrase read in as ambiguous as between two things. I'm just a little unsure what you mean.
We interpret the statute to require it.
Okay.
Fair enough. So, but courts have drawn the line. This court has drawn the line by saying it goes beyond the judicial role to sort of read required elements, and I'm going to clarify what I mean by elements, but read required elements into a statute. So, for example, Conley dealt with elements in the traditional sense of elements of a criminal offense and said, where a statute to be constitutional would require a particular element, and if that element were required, the statute would be constitutional, but the statute doesn't say anything about that element. And even though we could construe statutes all the time to require mens rea, the missing element in that case was knowledge that the conduct was criminally prohibited. And the court said, we can't read that. We can't interpret the statute to require that element where it's silent. There's no ambiguity. You can't interpret silence as incorporating a constitutionally required element. And then Tilley is essentially the same thing. I mean, the dissent's view in Tilley was the Sexual Psychopath Act would be constitutional if it required a finding that of some sort of mental abnormality short of mental disease. So let's just send it back and remand and have the trial court make that finding. But the majority opinion says that's not consistent with the judicial role. It's not enough to say that a judge could make constitutionally sufficient findings that under a properly drawn statute or a properly interpreted statute would justify civil commitment. But this statute does not require that finding to be made, and we cannot interpret the statute to require a finding.
Is it just a question of like how we have to figure out how impossible it would be for us to say this is what the statute means? Like, is it just, but that seems very case by case.
Well, to some extent it is case by case, but I think if you read Conley and Tilley, which really grapple with this whole issue of what is the judicial role in interpreting statutes to make them constitutional, they really focus on this idea of, is there a substantive requirement of the Constitution? And if that substantive requirement is not in the statute, then we cannot interpret the statute to require that. And that's different.
But I guess I'm just not, it seems that's a way of conceptualizing it, although it has consequences that are a little puzzling to me. But it seems like there's another way of conceptualizing it that one often sees, and I'm not sure which is the right way, or that the cases are entirely consistent because they both seem to be operative. But another way of looking at it is that a court, imagine that we were to resolve this case. Imagine that there weren't the questions of mootness that are present in this case. And imagine that we were to resolve this case by saying someone has come and said that there's a constitutional defect in this record, in this statute. The statute doesn't require some things that would be required facially. So we say this statute is unconstitutional as applied because there is no finding. I don't see why that would be reading anything into anything or fixing anything. It's just a limited ruling about a particular problem with the statute. And if your point is that if a different record where a judge had found a thing that a statute doesn't require that would make the statute that would fulfill all constitutional requirements, even though the statute doesn't require them and can't be interpreted to itself require them, that can never be a solution to a constitutional problem. That seems overbroad. It seems that then you could never fix a constitutional problem. So I don't see why you have to fix anything. You can just identify problems one by one, and eventually there will be a question about what's left and whether it's okay in a sort of common law adjudication setting. And it just to add one other complication, it seems in a way it starts wrapping over into severability concepts, because there are these ideas that sometimes there are constitutional problems with statutes that end up leaving things that don't make any sense and that the legislature wouldn't have wanted you to enact. And that's another strand of thought here, which you haven't really relied on. So I get that set of concerns, but I'm not quite sure the metaphor of fixing things or reading things in is the only way to look at it, or the only way that's operative in a lot of the cases.
Well, I think my number one response is the court grappled with what I understand Your Honor to be saying in Tilly, and said, we're going to strike down the statute. We're going to hold it facially unconstitutional. The dissent said, let's not do that. Let's remand for the constitutionally mandated findings. And the majority said, we can't do that.
That's a very fair point about Tilly. I agree. Now, on the other hand, there's this whole line of cases like in Salerno itself, one of the cases that features prominently here for multiple reasons, where the Supreme Court has said outside the First Amendment context, you can't facially invalidate a statute unless the statute is invalid in all of its applications. Then you get into these metaphysical ideas of what makes a statute invalid in all of its applications if it has certain kinds of flaws. But you know, like one of the 28K letter cases seems to reflect a much more freewheeling view about what ways courts can respond to statutes that don't on their face require everything that the Constitution might require. And therefore, depending on what else might have been proven in the case or found in the case, what happened might be lawful, though not, you know, again, running beyond what the statute especially requires. So I find myself very unsure about the relationship between Tilly and some of our prior cases and the Salerno line of cases. I'll just mention one other thing. Well, actually, that's more than plenty, so I'll hold off for now.
I say I'm out of time, but I assume you would like me to answer.
We'll
Okay.
give you more time.
And I have a question too. So,
Okay.
yeah.
So I said earlier that I read Conley and Tilly as being the cases of this court that clearly grapple with that question. I believe you were referring to Richardson, Henry Richardson. It's the 28K letter that read in a whole bunch of procedures that were not in a statute as to be constitutionally required. Richardson does not grapple at all with this whole idea of what is the judicial role in interpreting statutes that may have constitutional flaws. So it falls under that category of the judicial mind was not focused on that question. It doesn't say.
Richardson does this cute thing where it actually interprets the statute first and then looks at its constitutionality. So that works pretty well, right? If you do it that way. But
I guess that might work well, yeah.
This has all been very theoretical, and I just don't operate on the same plane as Judge McLeese. I need things more concrete. And I guess I'm wondering, I mean, we're sort of starting at the back end about, you know, what do we do if we see a problem, a constitutional problem, and do we interpret, do we read in, do we fix? And I guess I'm wondering, does this relate back to what's the nature of the problem that we identify, right? You know, our ability to interpret, read in, fix. And I'm just wondering if you have any thoughts about that and how this statute, how A2 maps onto Jackson, right? I'm just struggling to understand how, you know, and I'll certainly give the United States and the districts an opportunity to respond to this, but why a court in a criminal case would want to have unlimited authority to order continued treatment that heretofore has been to restore competency in a case where the court has said, I find this person cannot become competent. And Jackson said at this point, go to the civil commitment process. And in Macklin, we said, C1 is there for you, right? You get remanded to the inpatient treatment facility and you can be held by that inpatient treatment facility until you are civilly committed. You know, you get a little bit of process under C2, but you know, that path is clear. So I'm just trying to figure out under Jackson, if Jackson applies to this scenario, then what is our what's our ability to interpret, to read in, to fix A2? Why would we want to?
Well, I don't think you do want to. And the short answer is I agree with everything you said. You know, Jackson talks about reasonably related to the purpose. If you have a criminal court, if the point is that this is a criminal court acting as a criminal court, then its power to detain someone must be reasonably related to the purposes of criminal law, which are, you can detain someone for punishment, but you can't punish someone who hasn't been convicted. You can detain for competency restoration, but you can't do that after Jackson finding. And you can detain for preventive detention pending trial, where you think, okay, this person is so dangerous that we need to detain them until we can prove them guilty and then punish them. You can't do that after Jackson finding either, and certainly not under the, there was no preventive detention hold finding in this case. So yes, we're not saying the state as the state doesn't have the power to detain someone after a Jackson finding, but if they are going to do it, they have to do it through the civil processes, and those civil processes have to meet constitutional requirements. And we're not contesting that a probable cause hearing in front of a judge with a full evidentiary hearing that's required under precedent is constitutionally inadequate. And we're not saying that there isn't a statutory basis to give that to Jackson criminal defense. In fact, there is a perfect statutory basis. If you say, if this court were to hold that it is unconstitutional for a criminal judge to order continued treatment under A2 for whatever reason, then all that means is that everybody gets remanded to St. Elizabeth's. Nobody gets out, but everybody gets remanded to St. Elizabeth's, and they can demand a hearing, and they get it within 24 hours. And if the judge makes a finding, you are not dangerous by even the bare standard of probable cause, then you get to leave. And that you should get to leave after that finding.
Do you have a position about whether A2 as interpreted by the court in Macklin is itself constitutional? One could wonder, and I don't believe that issue was presented to the court in Macklin. I mean, it's only a probable cause finding. It is, has to be at the request of the defendant. And so one could, I think, make arguments that sound in some of the points you're making, though, again, they would be, certainly the disposition of this case wouldn't control that question. But I'm just curious whether you think, as with C4 at least, that some of the concerns that you raise also raise concerns about whether A2 and the procedures that it provides as interpreted in Macklin would be lawful or not lawful.
That may very well be. I don't want to, we obviously have not made that argument, and I don't want to preclude somebody else from making that argument. I think there are differences. It would be at most you're held for additional 24 hours. And then you get your hearings.
Although it's a probable cause hearing, which, again, one could wonder whether that's constitutionally adequate level of proof for purposes of detention. So
obviously it's not, no one's asked this court to decide those questions. Our position below and on appeal is we asked for the court to release and remand, i.e. detain us, but with some process. That's what we asked for below. That's what we're asking for on appeal.
Well, another way of asking an aspect of that question is, assume that contrary to one of your broader arguments, the court were not facially invalidating the statute. And the question was sort of what things could the court appropriately say about what the Constitution require as a minimum before detention under A2 would be lawful. And assume that one of the questions was okay, if some sort of finding of current dangerousness to self or others would be a prerequisite, by what standard do you think the Constitution would require that finding be made? Would you think a probable cause standard would be sufficient, or do you think the probable cause standard would not? If we were answering that question in this case, which is one way that court potentially on the decision tree could work its way through these issues.
Well, I do think, I mean, you know, nobody's argued that probable cause isn't adequate. I don't mean just in this case, I mean, in any case that I'm aware, nobody's argued that.
I thought the government, when it was urging us to, or when it was suggesting that if we thought any interpretation of the statute was necessary, I thought the government argued that a preponderance standard
that's
was
correct.
advisable,
I believe they did.
which I found surprising.
Well, and I think, honestly, I think this goes to reasons why the court should not undertake the endeavor of trying to interpret the statute in a way that meets constitutional standards, because the court would have to decide those questions. Is it preponderance? I mean, there's an argument to be made that you know, probable cause makes sense for somebody who has just come into the hospital within the last 48 hours. You're kind of still trying to figure out what their diagnosis is, and you don't have enough data to really make a confident prediction about their dangerousness. Whereas these people have been in the hospital for months and months and months. They've been observed. So you could argue there that a higher standard should be required under sort of the Matthew v. Eldridge balancing test. But then that creates maybe an equal protection problem, because now you have some people getting a preponderance and other people getting probable cause. And then maybe you have some people getting a preponderance hearing under A2, but then if they're found not dangerous under preponderance standard, they get remanded to St. Elizabeth's and they demand a probable cause hearing. And then they're held under a finding of probable cause, which is absurd. And you have to cross out the word status hearing in subsection A and make it evidentiary hearing, because due process requires a full evidentiary hearing. You have to say, I mean, the statute says the only determination to be made is whether a civil commitment petition has been filed. You have to now interpret that to require not only a determination that a civil commitment petition has been filed, but that a person is dangerous. What is the dangerousness standard? We say it's the imminent dangerousness, the emergency hospitalization standard, that the person is dangerous unless immediately detained. The U.S. Attorney's Office said they probably couldn't meet that standard in this case. But if they can't meet that standard, and if it's the civil commitment standard, what is the basis for holding the person now? Just wait until they're civilly committed if it's not an imminent requirement. And then, you know, the court is going to have to address what the procedures are, whether they should be the same as what you get under 525. Should they be different? What are the equal protection implications of that? So I think these are all the sorts of reasons in Tilly, the court said it's not consistent with the judicial role to try and read missing to try and interpret a statute to address these issues, where it's just going to raise a whole bunch of problems. And there's a quite simple and elegant solution, which is to just say the trial court's only option at this status hearing is to release and remand, which means detain, but with a hearing. Whether that ends any future constitutional claim about this statute, maybe not, but those, you know, that's how the court deals with constitutional issues on a case-by-case basis as they're raised. If the counsel doesn't
I know
like
we're
it,
belaboring this, but on one strand of thinking, that's what you just said is how I think is a way of thinking of why you don't need to interpret anything or facially invalidate. You just, you know, on this record, someone in a case that didn't have the mootness issues might say, well, look, here's some things that were missing, so not good. And eventually, over time, the upshot of all that would be that although the statute purports to confer authority to detain in, you know, without procedures and lots of other things, unless and until a court actually does everything the Constitution is required, the statute's purported authorization is unconstitutional. And you're not fixing anything. You're not reading anything into a statute. You're just adjudicating cases. And if, you know, eventually the government gets it right, then they'll make their way through threading the needle. And if they don't, they'll their case will fail. And so it seemed a little cross-cutting from your facial invalidity point to say we should be deciding constitutional issues as they arise case by case.
well, fair enough. I mean, but I'm not I think under our approach, you know, the constitutional issues are going to be discrete and you know, rare. Whereas if the court just says, A2 is constitutional if you apply some kind of standard and some kind of procedure that is inconsistent with the statutory language, but let's just put that aside and say the court holds it, figure it out. Judge Krauthammer said it's the wild, wild west. It would still be the wild, wild west. You would still have dozens or scores of people who are going to be unconstitutionally detained before these questions get resolved. You're going to have judge by judge. Every judge is going to have their own theory of substantive and procedural due process, their own burden of proof, their own, style of evidentiary hearing. And I just don't think that is.
But that must be true in a lot of cases where courts interpret a statute in a way that fixes, I know Judge McLeese doesn't like that, the constitutional problem.
Well, no, if an appellate court says, as kind of Richardson did, here's the procedures that you have to have. Well, okay, then a trial court has to follow those procedures. But if the court is to say, well, we as a court in this case aren't equipped to decide all these questions, which may have equal protection implications for other people. So we're going to leave it to the lower courts to figure out. And when a lower court stumbles on the right combination of standards and procedures, we'll affirm that, and then everybody else will know what to do. I don't think that's a good approach. I don't think that's an approach that's consistent with, I don't think this court has ever taken that approach. I don't think it would work for the reasons I've said, that it would by definition produce absurdity, where you have a judge saying, I find by a preponderance of the evidence that you are not dangerous, so I'm going to remand you to St. Elizabeth's. And if they find by probable cause that you are dangerous, then you remain detained. That's absurd. You'd have to not just interpret status hearing. If the statute said hearing, I think you could interpret hearing to mean evidentiary hearing or a full evidentiary hearing, as Herman says and Macklin says. But the statute says status hearing, so you would have to cross out the word status and write in the word evidentiary.
I keep struggling with that, because a different way of looking at it is an opinion from this court, and I do think this is it's not the only mode of interpretation, because Conley and Tilley are different. Though Conley is kind of in a funny setting where there's special concerns about notice to primary actors about criminalization of their conduct and like. So Conley seems a little bit further afield, but Tilley is, I think, very squarely in play here. But there's a whole other strand of adjudication that is much more case by case. So I think the court in this court has definitely taken that road too. You wouldn't be crossing out status hearing. You'd just be saying, if an issue came up and one of the issues was the defendant had said, I want to put on evidence with respect to this, and the court ended up saying, well, the statute purports to permit a status hearing, but the statute would be unconstitutional if a defendant was denied the right to put on evidence that was germane to these determinations, and therefore we remand for an evidentiary hearing. You wouldn't be crossing out anything or adding anything else. It's just the statute purports to authorize some things, but the Constitution requires other things, and if they aren't done, then exercises of authority under the statute will be invalid. So I do continue to struggle with the ideas of striking in or reading in or those kinds of things as the only way of conceptualizing this.
Right. So, what Conley and Tilley both do say is, if there's ambiguity, you can interpret the ambiguity in a manner that doesn't have constitutional problems. Status hearing is not ambiguous. So I understand what you're saying. I just don't think that's consistent with judicial role of interpreting statutes as this court has held in Conley and Tilley. So if Conley and Tilley weren't there, we could have interesting discussion about how courts used to deal with these issues. It kind of reminds me of,
Well, I get that line of thought for sure. And I think Conley seems to me somewhat distinguishable. Tilley seems very much germane here, more directly germane. But what are we supposed to do with the Salerno standard and all these cases that say outside the First Amendment? We're just not supposed to facially invalidate a statute unless the statute is unconstitutional in all of its applications.
Right. So what Tilley and Conley say is, because the statute does not require these findings to be made, it is unconstitutional in every case. Imagine you had a statute that says.
Sorry to interrupt. In fact, I'm not going to continue.
So you could have a statute that says a judge can detain any person for any reason. And we would say that's unconstitutional on its face. And the U.S. Attorney's Office would come in and say, well, it's not unconstitutional and no hearing. There can be no hearing. Hearings are forbidden. The U.S. Attorney's Office would come in and say, well, it's not facially unconstitutional because a judge could decide in his discretion, even though the statute says no hearing, I'm going to give you a hearing. And the judge could say, even though the statute says I can detain you for any reason, I'm going to say proof beyond a reasonable doubt that you're dangerous. And let's assume, put substantive due process aside, they'd say, okay, that's not a facially unconstitutional statute. All a judge has to do is ignore the statutory text and do what the Constitution requires. And I don't think that is a valid mode of statutory interpretation, certainly not under Tilley. And whether Tilley was rightly or wrongly decided, it is the controlling case on how to interpret, on the limits of the court's ability to interpret a statute that has a constitutional flaw. So if Tilley were not, if we were, writing on a blank, if the court were writing on a blank slate, we would have to, I think, grapple with these issues. I think a lot of those older cases do not grapple with these issues. Richardson certainly doesn't say, before we read all these unwritten procedural requirements in here, is that consistent with our role as a court? No, that's not something the court addresses. Judicial philosophy, I guess, has maybe changed in this area over time. Maybe these weren't questions that occurred to courts in the 1980s or 1970s. They are something that courts have grappled with more recently. This court has grappled with it very recently in Tilley. And for the reasons I said, I think even if the court were to try and interpret the statute in a manner to avoid constitutional concerns, it couldn't do that without, if not, I'm not going to say cross out words or write words in, but it would be describing something that is maybe the opposite or inconsistent with the statutory text. So you'd be mandating procedures that are inconsistent with the statutory text. And I think that is where it is clearest under Conley and Tilley that the court cannot do that in the mode of interpreting a statute to save it from a constitutional flaw. I'm well over my time, so unless the court has any further questions, we'd ask the court to reverse the detention order and remand with instructions to order the hospital to correct its records.
Thank you, Mr. Gonen. We will give you some time on rebuttal. Mr. McGovern, if you could let us know how time is being handled here.
Yes, Your Honor. Good morning, Michael McGovern on behalf of the United States. The United States will use 10 minutes and there's been an agreement for 5 minutes for the Office of Attorney General.
Thank you.
Your Honor, as this court recognized in JP versus District of Columbia, section A2, I'll use the nomenclature of Mr. Peyton's counsel, applies to a very narrow category of criminal defendants. Those have been deemed unlikely to attain competence as to whom a petition for civil commitment has been filed. What's more, its restrictions on an incompetent defendant's liberty interests are necessarily temporary and of a short duration, explicitly tied to the period of time necessary to provide those individuals with the more robust procedural process they are entitled to before a more permanent infringement of their liberties under the Irvin Act. The fact that section 07A2 is so narrowly drawn not only supports finding that this appeal is moot, but also that the provision is not facially unconstitutional and satisfies due process.
So can you walk me through the language of A2? Right. So you have someone who's been Jacksoned, been held for 30 days to determine whether or not a civil commitment petition is going to be filed. They've not been found guilty of a crime. They need not even be found to have committed that crime. There's no necessarily a probable cause finding for that crime. There's been no determination that the person is a danger to themselves or others by any measure. The only determination has been found that they are unable to understand the proceedings. And so why is A2 so narrowly tailored to a government interest of any sort?
So
what's the government's interest at this point?
Your Honor, the government's interest is in community safety, both the safety to Mr. Peyton, a member of the community.
But there's been no dangerousness finding, and this person hasn't been convicted of a crime or even found by probable cause to have committed the crime.
So, Your Honor, given that he was subject, that Mr. Peyton was subject to a stay away, no contact at the time that he was arraigned on these charges, he would have in fact been entitled to a probable cause determination. His counsel didn't raise that at the arraignment, but under the criminal rules, he would have been entitled to a probable cause determination.
Okay, so because he would have been invited, according to your argument, he would have been entitled to some process, but no determination has actually been made or need be made for a defendant who gets to this point. I mean, I'm talking generally. I'm not just talking about Mr. Peyton.
Well, I disagree as a general matter that that individuals would arrive at this point without a probable cause determination. And for the purposes of a facial challenge, we're looking at whether it's constitutional in all of its applications. And certainly there will be individuals subject to 53107A2 who came into the system through an arrest warrant. And so there would necessarily be a probable cause determination.
Can I ask you, you identified the idea of a facial challenge and unconstitutional in all of its applications, and Mr. Gonin anticipated a hypothetical I was wondering about, so I'm interested in your response to it. Imagine that tomorrow the DC Council repealed the current detention statutes, pretrial detention statutes, and provided enacted a statute that said the trial court may detain any person charged with a crime in the District of Columbia. Is your view that that statute is not subject to facial challenge because although, because some people warrant detention under constitutional standards, although the statute doesn't really say anything about what process, what standards or anything else, you would say not facially invalid. And instead that would be kind of adjudicated on a case by case basis, depending on what the record was and what law developed in this court over time about what the Constitution required by way of process and substantive standards and the like.
Yes, Your Honor, to the extent that the use of the word may requires a court to exercise its discretion, the question that would be asked in that case was the exercise of discretion constitutional? And that is a question that sounds very strictly in what the Constitution legally requires. And so in passing that statute, there is a constitutional application. There are individuals who may be detained.
And how do you square your answer to that question with our decision in Tilly, which seems to be difficult to reconcile with that way of looking at things?
In Tilly, one of the issues was that the DC Circuit interpreted that statute in order to find that there was no equal protection issue with respect to individuals. So it found that under the terms of the statute, it could only survive equal protection scrutiny if individuals who were determined to be sexual psychopaths were not individuals that were mentally ill, and then said that that is the only way you could provide a different process to those individuals in order to commit them from regular civil committees, and then found that given the expansive definition of mental illness under the Irvin Act set the floor for constitutionally who could be civilly committed. And so there was no additional group of individuals who could be civilly committed. So therefore, the only construction of the statute that was available was one that was unconstitutional under due process. And so it was the combination of factors that under a reading of the statute, which avoided, and that's how I would read, instead of the fixed language, Judge Beckwith, I would say to read to avoid constitutional issues.
Can I ask you then, is your point something like the hypothetical I gave you would be different if the statute said any defendant may be detained any defendant charged with a crime in the District of Columbia may be detained, period. No evidentiary hearing, no evidence may be introduced in connection with that detention. And then your theory would be that that statute by its terms seems to explicitly preclude. It's not that it doesn't provide everything the Constitution entitles you to, but it explicitly precludes something that the Constitution entitles you to. And that kind of a statute can't be fixed. Is that, to use a metaphorical term that I was just objecting to earlier, so I'm not sure why I used it.
Yes, Your Honor, it would be that the statute, a constitutional application of that statute would be irreconcilable with the statute as written. And here, that's not the case.
So I'm confused then. What is this case about? If you're saying, if I understand your argument, well, the Constitution is always there as the floor. And so you can't have, unless you have a statute that squarely says something that's irreconcilable, you always have a statute that can be interpreted consistently with the Constitution. So that's all that needs to happen here. So this court could say, well, the Constitution seems to require that someone cannot be held outside of the criminal justice system without a finding that they're a danger to themselves or others. And that hasn't happened here. So, I mean, why wouldn't we just say that is what A2 requires? But it sounds like the government doesn't want us to say that. Guess they didn't want to hear that question. Sorry. So if you heard me, I'm trying to understand why we're here. I mean, it sounded like the government didn't want more process, right? Wanted to say this person's treatment should continue under the supervision of the court in a criminal case. Don't remand to the inpatient treatment facility where they might have access to a probable cause hearing. But now the government is saying, don't worry about the constitutionality of A2. The Constitution is there as a floor. And so obviously trial courts have to do everything that the Constitution requires, which seems to require a finding based on evidence and some burden of proof that someone is dangerous to themselves or others.
So I think with respect to the legal proposition of whether this could be read in, I'll point specifically to language in Tilley, which supports our position. And that's at 970 of the opinion, where they say that constitutional invalidation is only necessary, and I quote, if the legislative design and the limits of the judicial function do not permit us to read the critical missing elements.
I'm sorry, this isn't exactly where my question is going. I'm trying to figure out what the government's, and maybe I'll focus right now on the United States government as the prosecuting entity for the District of Columbia. What's the United States government's interest in this case right here, right now, in this posture? If the United States government is saying, well, the Constitution is always there for A2, why are we here?
For the community safety interest, for individuals who have been determined.
The United States government doesn't have a parens patriae authority over the District of Columbia, separate and apart from its authority to prosecute crime.
Well,
here's someone who cannot be convicted of a crime because they have been Jacksoned. So, and now you're saying under A2, well, don't worry about continuing treatment in a criminal case for sort of general public safety reasons where there's been no dangerousness finding, except that you're saying, oh, it's okay, the court can make a dangerousness finding to comply with the Constitution. I'm just completely confused why the government is litigating this case. If the government is totally fine with the constitutional protections that are afforded to people who haven't been convicted of crimes and are not before a criminal court.
Your Honor, Greenwood versus United States indicates that the United States does have a continuing interest in seeking civil commitment of individuals who have been found to be incompetent to stand trial. And in this case, the procedures that the council provided do provide the floor of due process to these individuals. First, they are put on notice that they may be subject to continued deprivations of their limited deprivations of their liberty. They are provided for a hearing before a neutral magistrate. This is not a case where continued treatment may be ordered out.
Which hearing are you talking about at this point?
The A2 hearing, Your Honor. The the statute specifically requires that there be a status hearing. It's specific.
Right, the status hearing is just to determine that the civil commitment petition has been filed.
And for the court to determine whether to order continued treatment or to release in the criminal case. And that determination is an execution of.
I mean, it doesn't
judicial
say that
discretion.
has to happen at a hearing. Right? It says that you have to have a status hearing to determine whether the civil commitment proceedings have been initiated. That's under A1. And then, you know, you can have that hearing and it sounds like, I mean, maybe it happens at that status, but then at A2, it says, you know, if the petition has been filed, the court can just issue this order. I don't know. I mean, I don't know when the court issues the order.
It appears that the statute contemplates that is being made at the time. That's the time that the individual is before the court, that the need to determine what happens after the filing of the civil commitment petition is squarely at issue at the time that the status hearing occurs.
And you're seeing that in A.
In subsection A and A, the way
And
that A
A1.
operates, both A1 and A2. It's you read the statute as a whole. It shouldn't be looked at in isolation. It should also be read consistently with the fact that in C4, they require that the status hearing 30 days later in order to make this determination.
Yeah.
And
In A, it just seems like unusually specific in that it tells us what the status hearing will be for. It is to determine whether civil commitment proceedings have been initiated.
But then A2 goes on to state that if there has been a petition for civil commitment filed, it may order continued treatment and requires that on the basis of information the court learns at that hearing.
No, it doesn't. It doesn't say anything about that decision being on the basis of information learned at the status hearing. Or, I mean, I don't see that.
The status
hearing has, according to the plain language of the statute, has one purpose and one purpose only. Has a civil commitment petition been filed, right? And if it hasn't, then you can get released immediately, or the government can say, please, please, please give us a little bit more time, and the court can give you 5 extra days. But if the petition has been filed, then there's this fork in the road. And the statute doesn't say anything about when that decision has to be made, right? The court could say, okay, you filed the civil commitment petition. Now I'm going to figure out, and I'll take it under advisement. I'm going to figure out in my own due time what I'm going to do. And it can make its A2 decision. There's nothing in the statute that says that you have to have a hearing, entertain argument on this question of whether or not the court itself directs treatment to be continued until the final order of civil commitment, or whether it releases the person who's inpatient and they go under C1.
Yes, Your Honor. So when you read the provisions in isolation, but we would submit that statutes should be read according to their structure. And the structure is that large subsection A sets forward a hearing that will occur before the court.
Okay, but
And
it's
then
still, let's just assume that that's right, that this all happens at once. And there's a status hearing and the court finds out whether the civil commitment petition has been filed. Then what, right? I thought you were saying, well, don't worry, the Constitution assures you that in this decision about whether or not treatment will be continued by the court in the criminal case, the criminal court will figure out whether or not the person is dangerous to themselves or others.
Your Honor, the statute then instructs the judge to exercise discretion, and an exercise of discretion can only be done legally if it's done in accordance with the Constitution. And so by the counsel vesting in the judge's discretion as to whether to order continued treatment, This court, to the extent it finds that the Constitution requires continued treatment, could only be ordered where there's a finding of dangerousness.
By preponderance of evidence.
That's,
I think that's what the government argued, right? That's the standard,
the government has argued that
the baseline
the,
burden of proof.
the government has argued that the fact that there was no standard set forward in a statute doesn't indicate that there's no standard that it is standardless. It's
Right, and I thought the government said it's not standardless, you just go to the default, which is preponderance, that's the baseline.
correct, but you could
Okay,
also
so,
interpret.
I mean, what am I missing here? So the government is saying, if we're under A2 and the court is making at this status hearing, has confirmed that a civil commitment petition has been filed, then what the trial court should do, because the council in its wisdom knows that the trial courts follow the Constitution, what the court should do is make a dangerousness finding by preponderance of the evidence, which seems to require an evidentiary hearing, because if you don't have evidence, then it's hard to find anything by preponderance of evidence.
To the extent that the court is concerned that there is not an express standard stated, there is.
But why is it to the extent? I mean, I'm just looking at the plain language and none of this is in here. So I thought that you were saying, no, it really is in here. It's just implied.
The argument that the government made in its reply brief is that there is an exercise of discretion that is granted to the trial court, that the exercise of that discretion may be constitutional. There are constitutional ways to exercise that discretion, and that provided that a court complies with that exercise of discretion.
Shouldn't we tell courts then? I mean, it just seems, I'm just not quite sure what the government is asking for. The government is saying, don't worry. I get that part of the government's argument. But then what? You do want us to say that there is a requirement of dangerousness by preponderance of evidence after an evidentiary hearing, or you don't want us to say that? And if you don't want us to say that, why don't you want us to say that?
The government's position is that this court should deny the request to strike down this statute as facially unconstitutional, because there are constitutional applications of this statute. We believe in this.
But after that, I get that as part one, but I think assuming we agreed with you about that, and then we went on to say the statute here, if we're going to shed light on what kinds of applications would be constitutional, and if that light was focused on dangerousness or not, maybe it just going step by step. Does the United States agree that the Constitution requires for this statute to be constitutionally applied that there be a contemporaneous finding of dangerousness self or others at this status / evidentiary hearing? Do you agree with that, or do you dispute that?
The government believes that if there is a crediting of the petition and the allegations therein by the court, that supplies the requisite constitutionality.
But
The crediting of the
petition
petition by the government, by the district government, right? The district government here filed the petition for civil commitment.
Correct, Your Honor.
So, I mean,
I
saw this
the
in I
judge.
saw this in the government's brief. The government said, well, the court finds that a petition has been filed, right? Essentially, the court finds that the government wants to prosecute this person for a crime. The court finds that the district government wants to civilly commit this person. What value is that as a constitutional matter?
Well, I think there are a number of findings that have been made besides that.
But leave aside this case and just more abstractly, if your point is you think that it would suffice the Constitution for a trial judge, the requirements of the Constitution for a trial judge to, without holding an evidentiary hearing or hearing any evidence from somebody, quote, credit the allegations in a petition, that seems like a potentially troubling line of thought. But that's your position is the trial court could have in this case to satisfy the constitutional requirements, could have looked at the petition and said, yeah, on the face, I kind of credit this. And the defendant could have said, well, that's really interesting, but I'd like to actually put on evidence about it. And the trial judge could have said, sorry, no, you're going to have continued treatment for a couple months, maybe more. And your view is that would be constitutionally adequate?
No, Your Honor, to the extent that the defendant said, we dispute these, or there's information that we would like to put before you, we believe the trial judge would be required
Constitutionally
required to consider that.
And what burden of proof do you think would be required before a trial court could constitutionally exercise the discretion conferred under this provision to order detention pending the completion of the civil commitment proceedings?
I think probable cause was what was established in the case of urban defendants when committees, when there was the DC Circuit interpreted the similar hearing provision of 21-525.
And do you think the Constitution requires also a finding that mental health treatment that is connected to the dangerousness, so some kind of nexus between the mental health treatment that would be needed or that would be contemplated and the dangerousness? Do you think the Constitution requires that?
I do believe that the reasonable relation standard that's articulated in Salerno, that the detention or the infringement has to be reasonably related to, both in duration and scope, the reasons for detention. If there was no treatment available, then it wouldn't seem that ordering to address the dangerousness.
That's a partial answer, but just to clarify my question. I mean, it's a funny feature of this statute that it both at the 06C4 stage and at the 07A2 stage refers to either treatment pursuant to earlier provisions or continued treatment. And the treatment that has been the subject of prior orders is to restore competence. But at the time someone has been the subject of, Jackson finding that they're unlikely to regain competence, that kind of treatment doesn't seem sensibly in the picture anymore. Do you agree with that?
I agree that treatment for the purpose of regaining competency is no longer, given the Jackson finding, the type of treatment that would be contemplated.
Right. And so the treatment that must be contemplated is treatment of, again, assuming someone who has mental health issues that would be treatable in an inpatient facility. Not everyone who's incompetent would fit into that picture, I think, but assuming someone who did, the treatment that would be contemplated thereafter that the Constitution would permit to be ordered would be treatment of whatever mental health conditions has a nexus to the dangerousness that the Constitution would require to be found. Do you agree with that or not agree with that?
I do agree with that, Your Honor.
And do you agree that the Constitution would require, before that treatment could be done inpatient, that a determination be made that inpatient treatment is the least restrictive way of addressing whatever dangerousness and mental health issues the trial court had found?
Your Honor, what we argued in our brief is that the reasonable relation standard does incorporate some aspect of the least restrictive alternative, because to the extent it's not the least restrictive, it's difficult to show that the detention or the treatment is reasonably related to its goal.
And finally, on this list of questions I had along these lines, do you agree that the Constitution requires for this exercise of discretion under the statute to be lawful, that the danger to self or others be immediate or imminent or some word like that, that it be shown to be a matter of short-term concern rather than longer-term concern?
I think the standard as it's been articulated is that the individual is dangerous to themselves or others if they are not immediately detained. And I do point that out for a very specific reason. And that's because the need for immediate detention to prevent harm is different than a finding that an individual is immediately dangerous. And I say that because of the nature of mental health that this court has recognized. And here in this particular case, we have a case where the defendant was receiving mental health treatment and medication for his mental health condition. At the time that he went into inpatient treatment, he stated on the record that he was on certain antipsychotics. And then we know that in the course of the 4 months that he was in inpatient treatment and not being compliant with his medication, that he decompensated to the point that he was presenting a physical
Well,
safety issue.
you say that we know that. There's information in the record indicating that, but there's never been a hearing about that. And there's a debate about the extent to which the trial court's orders constitute a finding of any of it.
Your Honor, there is record support for that, and there was no challenge to those reports at the time those reports were entered. Rather, to the extent that DBH had
At the
provided.
time those reports were entered, the question was competency, right? So, and here we're talking about continued detention for a completely different purpose. Can I just go back to what you just walked through, Judge McLeese, with, you were talking about what you think the statute A2 requires to be consonant with the Constitution. But none of that is in A2. So I'm just wondering, why does the government think it is not facially unconstitutional? If it just doesn't say any of this stuff, then why should at least the part that allows the court to order treatment be continued, the court in the criminal case?
Your Honor,
Why shouldn't that be struck?
Your Honor, I would point you to the Supreme Court's decision in Kent versus United States, where there's what I would consider an analogous situation. And in the Supreme Court's decision in Kent, it specifically noted of a DC provision that allowed a court, upon its discretion, to waive jurisdiction over juveniles in order to have them prosecuted as adults, that the statute states the circumstances in which jurisdiction may be waived and the child, but it does not state standards to govern the juvenile court's decision as to waiver. And the court didn't strike down the statute that provided for the discretion to waive. What it did was it found that the process that was employed by this particular court in its waiver of jurisdiction was unconstitutional. And what it did was concluded that, quote, as a condition to valid waiver order, petitioner was entitled to a hearing, including access by his counsel to the social records and probation or similar reports, which presumably are considered by the court, and to a statement of reasons for the juvenile court's decision. We believe that this result is required by the statute read in the.
I'll look at Kent, but we're operating under Jackson, right? And Jackson already set the table for us and said, if you have a person who has been charged with a crime and deemed to be incompetent and not likely to become competent at any point in the foreseeable future, such that they cannot be brought to trial, then you have to decide in a limited period of time whether or not you're going to initiate civil commitment proceedings or not. And this statute seems to say, A2, well, you can initiate the civil commitment proceedings and shunt someone into them under C1, or you can just have the criminal court continue to maintain custody over this person and order their treatment. And that just seems antithetical to Jackson. That's what Jackson said can't happen. So I'm trying to understand, I mean, you want to read all of this process into A2 to make it okay, but why isn't the part that says the court in the criminal case can just continue to order someone to be treated unconstitutional under Jackson?
And we would argue that the interpretation of Jackson that narrowly, that immediately upon the Jackson hearing, there's no interest for the state left, was rejected by this court in Thomas versus United States when it considered the provisions that were applicable then, where criminal courts continued to detain and offer treatment to individuals who had been found incompetent and unlikely to regain.
Thomas wasn't interpreting this provision, right?
But they were interpreting the same process that ended up becoming this provision, that there would be a hearing held by the criminal court at which they determined continued treatment was appropriate for this individual. And that's the process. And in fact, as the district points out in its amicus, it was the exact time period that Thomas set forth with respect to the time to determine whether a civil commitment would be filed that was incorporated into the IDCCA. So
Thomas, am I right to thinking that Thomas predates the Supreme Court's decision in Faucia? I think I don't have Thomas in front of me right now, but Faucia was 1992. I'm thinking that Thomas predates that, but I may be temporarily disoriented. And the reason I ask that is because there's language in Faucia that seems to be difficult to square with the idea that there's kind of a relatively unconstrained transitional grace period. So the idea, one idea is you have someone who's in the criminal setting, they've been determined to be incompetent and unlikely to regain, they've been detained and mental health treatment for those reasons. There needs to be kind of an orderly transition over to a civil commitment setting after a Jackson finding. And, there's a reasonable latitude to just, without a lot more process, without really any need for additional findings, just say, okay, we're going to start that train up running and we'll keep things pretty much as they are as far as the status of the defendant. That's the line of thinking. But the language in Faucia, now Faucia is in a different setting because it's for sure someone who there was a question about whether the person suffered from mental illness and all, but the general language in Faucia as seeming like an independent point, this is on page 78 of the opinion, says keeping Faucia against his will in a mental institution is improper, absent a determination in a civil commitment in civil commitment proceedings of current mental illness and dangerousness. So the kind of line of thinking that is to a degree seemed to be reflected in Thomas of, you don't really need a ton of process here, seems a little bit out of sync with where the Supreme Court has been headed thereafter.
Well, I think what was important was that Faucia was pointing out that there are two findings that need to be made. I don't think that the fact that it occurs in a civil commitment proceeding as opposed to in the criminal court makes a distinguishing difference in Faucia. That simply wasn't sort of the focus of Faucia's analysis. And I think am I right in understanding that whatever latitude Thomas seemed to accord at one point, your answers to some of the questions I asked today is that you seem to agree there needs to be, at the time of an A2 order, there needs to be a determination of current mental illness and dangerousness. Yes, Your Honor, and specifically that A2 does, in the fact that it requires that this detention or this continued treatment, and again, it's not, the treatment under the statute can be on both an outpatient or an inpatient basis, but that continued treatment may only be ordered where there has been a petition for civil commitment filed. And that means that there has been a statement by doctors made on the record that this individual is a danger to himself or others as a result.
See, that's where I start getting a little confused, because at times you seem to be saying that you don't really need a determination in a proceeding of dangerousness and mental health, ongoing mental health issues. It's enough that there is a doctor somewhere who was willing to say under oath, and I don't mean to just disparage the doctors. I'm sure the doctor would be saying that in good faith, but sometimes doctors are mistaken. So it seems there's a pretty big difference between there's a document in which a doctor alleges or concludes certain things and a determination in a proceeding of those things. And in some of your answers to my questions, you seem to acknowledge the Constitution requires a contemporaneous finding. At other times, you seem to be suggesting something short of that, like a petition that reflects conclusions of a doctor would suffice. That's where I'm not sure I know exactly.
Yes, Your Honor, and I suppose my answers have perhaps been confusing on this issue because I'm considering it in light of In re Barnard, where the court said where there is before the court a petition and there is no assertion from the other side that there is any factual misstatement in it or any reason not to credit it, that could be sufficient for the purposes of the probable cause hearing that's available in 525. And
to be clear, if I understand your point is you're not suggesting that in and of itself, without regard to further context, a declaration by a doctor would suffice. You're saying that it might in a case where there was an opportunity to contest it and that opportunity was not seized.
Correct, Your Honor.
Okay. Can I ask you, this is it wasn't really briefed this way, I don't think, unless I missed things, which is quite possible, but something that Mr. Gannett said today suggests less of a facial invalidity point as a matter of sort of constitutional doctrine and more a point about absurdity and severability, perhaps, which is, if I capture the gist of his thought, it is the legislature created two options. There's A1 and there's A2. And one option puts you off into civil commitment and gets you a bunch of findings, and the court interpreted in Ray Macklin the somewhat confusing provisions at issue there and explained what that process would be. And then there is another option, which seems to be very different and kind of a short road home without requiring all of that process. And if the Constitution ends up requiring that first, the short, what seems like, and maybe the legislature intended to be a short way home, really isn't. In fact, in some ways, it's either you get a hearing, you get a determination right then rather than later. It's you don't have to expressly request it the way you do 24 hours later. So in some sense, the process seems more robust on the A1 side if it requires what you say the Constitution requires. And the question is whether that system is just, if you interpret A1 that way, it makes no sense to coexist with A2. And really, that's not, you should just acknowledge that and say the only reasonable option, the only option the legislature could possibly have intended, if it understood all of the constitutional requirements that you're acknowledging need to be present for an exercise of discretion to be lawful under A1. So do you have a response to his argument that if the Constitution really requires all of that, A1 just doesn't make any practical sense, and it should be jettisoned for that reason, if not for facial invalidity as a matter of constitutional doctrine?
I think the distinction is that, in fact, what the council intended through A1 was to give the question of continued treatment to the criminal court, who had familiarity with, and this was important to the court in Thomas, had extensive familiarity with the mental illness and how it presented
This
itself.
is an equal protection case. So I thought we were talking about sort of substantive due process. I'm confused. Why do you think Thomas resolves this question for us?
I think in response to Judge McLeese's question regarding what was intended by the council between A1 and A2, and to the extent there's a conflict or an absurdity between the two, what would be the appropriate remedy? Would it be to strike one or the other? That the council's intention here, and the reason that this is not facially unconstitutional, is that this is not facially unconstitutional, and that the council intended to provide that exercise of discretion to a judge who was intimately familiar through the competency proceedings with the mental health presentation of this defendant. To the extent that Thomas was an equal protection, it still addressed, it number one did have a reading of Jackson, which rejected a curtailed view of how long continued treatment could be ordered in a criminal case under Jackson. And so I think it's relevant in respect of that.
Relevant, but certainly not binding.
I think it provides an interpretation that this court relies on of Jackson, which is necessary to its conclusion. And so is a statement of what it believes Jackson's constitutional requirements are.
In your view, does Thomas involve a dangerousness finding? Does the criminal judge make one in talking about the crime, the child being thrown out the window? Is that what suffices as a dangerousness finding?
I think in Thomas, the court was intimately familiar not only with the allegations there, but the court also noted that the criminal court was intimately familiar with the multiple Jackson hearings and statuses that had occurred, and so how he was presenting in that time, and was also familiar with the civil petition, the civil commitment petition, which alleged that he was a danger to himself and others. To the extent there was no express finding, and certainly I don't want to represent that Thompson says there was an express finding of dangerousness made. I think that does relate back to Judge McLeese's point that perhaps at that time, in the absence of Foucha saying there needs to be a determination of dangerousness specifically, that process still provides for the constitutional adjudication of that issue.
Can I ask you, do you've acknowledged that for exercises of discretion under A2 to be lawful, certain constitutional requirements not explicit in the text would have to be present. If that's a fair characterization of your point. Do you think the same is true about 06C4? So it seems to say that without any further finding, once there's been a Jackson determination, the trial court can enter an order where appropriate, enter an order for treatment pursuant to 53105A. That's a bit of a glitch because that treatment is to restore competence for up to 30 days pending the filing of a petition. Do you agree, or what's your view about whether the Constitution requires before the entry of such an order that there be a finding of dangerous to self or others, that there be an opportunity to contest that at a hearing, evidentiary in character, that there be a finding of current mental health issues, that there be a nexus between those mental health issues and the dangerousness, that there be a determination that that would be the least appropriate, least restrictive environment to address those issues, and that there is an immediacy component to it? Do any or all of that required under C4, 06C4?
Your Honor, I don't know as I stand here that I have thought about that issue in enough detail to give an answer that is conclusive on what the United States position is. Certainly, it hasn't been addressed by the party's briefing. Certainly, it's not presented in this case. There was no objection to the C4 provision here, and it wasn't challenged as unconstitutional. And so I hesitate to make those statements because I think the governmental interests at that point are slightly different than the governmental interests once there's been a determination that civil commitment won't be sought or the civil commitment will be sought. And so I hesitate to say immediately what that would be. I will note, though, that in C4, the legislator does grant discretion and limits it to as is necessary for the completion of civil commitment proceedings. And this is in C4 that the court, the final sentence of that is the court also may order treatment for such periods as is necessary for the completion of the civil commitment proceeding.
Well, I understood that provision to relate to, I mean, it's relevant to how to interpret 07A2. I didn't understand it to be a prerequisite to the exercise of the 30-day authority conferred in the earlier sentences of C4. Are you saying you think that, I mean, C4 at the beginning says you can order this 30-day treatment, continued treatment pursuant to 05A, where appropriate?
Where appropriate. And so it does provide for.
Do you agree, though, that the language about as necessary is, it doesn't relate to the authority of the trial judge to issue a 30-day order pursuant to the preceding sentences of C4?
Correct, Your Honor. The way the statute is structured is that where appropriate is the standard by which it said that C4 should be entered, and as necessary is the standard for A2 as articulated in C4.
We've kept you up here a very long time, Mr. McGovern.
Thank you, Your Honor.
If you want to make a wrap-up sentence, you're welcome to, but otherwise we can.
We would ask that you affirm or dismiss as move this appeal.
Thank you. Now we will hear from the district. Ms. Johnson.
Morning, may it please the court. A2 is not standardless because it says may, and may implies an exercise of discretion. Now, what is the standard the court must apply? The court can then look to a few different factors. First, this status hearing takes place after the civil commitment petition has been filed. So we know that the court's going to be basing its decision on something that has to do with civil commitment. And second, this court can look to Thomas. And I think this is important because I don't think that there's any dispute that Thomas is what was codified in A2. And in Thomas, the court said that in particular, what it was in particularly swayed by when it made what really was a due process determination, and I'll circle back to that, that the court relied on facts underlying the criminal charges and the psychiatric report that the person would be dangerous to himself or others if released. And we believe that is the standard that applies under A2. What I want to emphasize is that what we're asking the court to do is exactly what the DC Circuit did in Barnard. If this court looks at 21-525, and that's the hearing that someone under option 2, under the release to DBH option gets, the standard there in the statute says the court shall grant a hearing That's all it says. Doesn't provide a standard, doesn't say what the court's basing it on, doesn't provide a standard of review. Barnard looked at that, and this was the DC Circuit. I think it went to the DC Circuit because the authority shifted over to the DCCA in between when the district court had the case and when it went up. So Barnard was a 1971 case, and Barnard did a lot with that statute, reading it in so that it would be constitutionally valid. And whether you want to call it fixing the statute, changing the statute, or just interpreting it in a way that's valid, that's what we know the court is required to do.
Can I
And
ask you though, as to Judge McLeese's question to Mr. McGovern, even if you can interpret Thomas as a due process case, does it survive the, Zinnerman and Fausch, which follow?
I'm going to say yes, absolutely. And I'm going to unpack this a little bit. First of all, I want to be clear that Thomas indeed was addressing due process and not equal protection. And the reason you know that is in fact, from what Judge Easterly said, what Thomas is doing is interpreting Jackson. Now, Jackson has two separate sections. It has an equal protection section.
I mean, sorry.
I
but
apologize. I shouldn't have imputed that to you.
No. I'm just saying, and I'm the imputation is fine. My problem is just because the analysis in Thomas is messy and imports due process precedent into an equal protection case doesn't turn it into a due process case. It's an equal protection case. It says we have an equal protection claim and it makes an equal protection holding. And so, I mean, we could look at the due process discussion as dicta, but it is not binding on us if that is not what they held, or at least that would be my way of viewing Thomas.
Absolutely. And that's a fair way of reading it. We believe a better reading is that it is binding, because the way you really look at whether something is binding is you look at what was the argument they were making, what was the reason it was rejected. The argument he was making is I'm entitled to emergency hospitalization procedures and not this holdover provision that got codified as A2.
On an equal protection argument.
So now I want to explain. I mean, he brought that as an equal protection claim, but that's not how the court addressed it. And so I want to get into that because Jackson has two entirely
We
different sections.
conclude that under the circumstances, appellant was not denied equal protection of the law.
Your Honor, I absolutely concede that sentence is in there. I'm trying to explain why I believe it's a different holding than that. So I just want to explain that.
Okay, so you're telling me that the holding is not what it said it was.
I'm just going to explain my position. And
Got it.
obviously you're going to take the point that you take from it. It can be interpreted different ways. So Jackson has two different sections. It has an equal protection section and has a due process section. The equal protection section does not address any of the matters that are at issue under A1 and are at issue under Thomas. What Thomas is quoting from Jackson, what it's quoting when it says, we believe that this process satisfies Jackson, is the due process section of Jackson. And I'm going to leave that there because I do also want to address then what happened with Fauci, because I think that that's important as well. So Fauci, the way I read Fauci, and I'll explain why I think this is an important and the only way to read it. What Fauci says is that the defendant was entitled to a civil commitment trial. Fauci didn't say he was entitled to release pending his civil commitment trial. Fauci was not getting a civil commitment trial at all. He was being held as someone who was not considered mentally ill, and he was being required to prove that he was no longer dangerous. So the civil commitment proceedings in Fauci that are referred to in the quote that Judge McLeese you referred to, that you quoted, those are civil commitment proceedings, which are the trial, or what we would say is the first time you really get adequate or more process is at the commission hearing. Now, the reason why we know this, or
I'm trying to understand your point. So, I mean, the sentence seems to, that I was quoting, which is on page 778, the one you're referring to, says keeping Fauci against his will in a mental institution is improper, absent a determination in civil commitment proceedings of current mental illness and dangerousness. And you're saying that shouldn't be read to say you can't have any detention unless you've had that kind of a finding, because the finding that was referred to at the end there, the civil commitment proceedings that were referred to would have been at the end, like the trial at the end, and therefore I'm not sure I follow.
Okay.
Even if it's right that whatever was referred to there as civil commitment proceedings was contemplating the ultimate trial, I'm still not quite sure how that bears on understanding what seemed to be the point of the sentence, which is you can't keep this person against his will in a mental health, in a mental institution, absent a determination I mean, somewhere, but in civil commitment proceedings of current mental illness and dangerousness. So I'm not quite sure I get how you unpack the point you're making about how to interpret the phrase civil commitment proceedings to understanding the import of the sentence.
There's a lot of nuance in these issues, so let me clear that up and unpack it. Fauci, Jackson, most of these cases, what they're concerned about is indefinite civil commitment, because that's what it means. When you get civilly committed, there's a decent chance that somebody's not getting out. So they're talking about indefinite. They're not talking, generally speaking, about the window of time between when someone is found incompetent to stand trial and unlikely to regain competency and the time in which they have had their first full-fledged evidentiary hearing on civil commitment. They're talking about whether they get that full-fledged evidentiary hearing at all. In Fauci, the defendant was not getting a hearing at all. Now, and I want to emphasize one of the reasons we know that Fauci was not addressing that interim period.
I'm sorry, but Mr. Peyton wasn't getting a hearing at all until, I mean, he's been held just to determine whether or not he's competent. There's been no hearing on dangerousness. And now, because the trial court, for reasons that are unclear on the record and are not elucidated by the statute, just decides to keep holding him, right? I mean, where is the process that you think that he gets? Where does that come in?
It comes in at the commission hearing, which was scheduled for 5 weeks after his Jackson finding. He's the one that continued that so far into the future. So
it sounds like your answers may be very different to some of the questions I was asking than the attorney for the United States. So are you saying that you think it's constitutionally fine that after a Jackson determination is made and we get to the point after C06, C4 and a petition has been filed and we're at the A2 point for the trial judge to say, to order continued mental health treatment in the criminal case without making a finding of current dangerousness by any standard?
So I have two answers, and this is why I keep trying to go back and talk about the federal statute, because I think that's important. I think that under this statute, because it gives the judge discretion, that the standard that has to be applied is the same standard that would be applied by the family court in the probable cause hearing. But before I get to that, I want to talk
My question was about what the Constitution requires. Though.
Well, and that's, let me get to that, sorry. So the federal civil commitment process.
I'm sorry, I know you want to talk about the federal statute, but I just want to make sure I heard you correctly. You said that you think that the process that is due under A2 is the same for someone whose commitment is continued, or whose treatment is continued by the criminal court. You think their process, the process that they are due, is the same process that someone would get if they were remanded to the inpatient treatment facility and had access to a probable cause hearing? Did I hear you correctly?
Yes, I think that is the best interpretation of the statute. I think it is consistent with the Constitution.
Why are we here?
Because it is really.
I mean, I'm sorry, I don't mean to be flip, but
I know.
I've got the government, the United States government saying, don't worry, under A2, someone is entitled to a full evidentiary hearing where dangerousness is determined by preponderance of the evidence, which I think Mr. Peyton, if he had had access to that, would have been very happy with. And now I've got the district saying, don't worry, under A2, if the criminal court decides to continue treatment, you get the same process that you would had the court released the individual to the inpatient treatment facility. So it just, I mean, if you get the same or more, what are the governments arguing about? Why are we here?
The district is here because we want to preserve the council's policy judgment that the criminal court gets the first opportunity to decide whether someone is too dangerous to release. That is a striking A2.
Fine. I mean, I like, so, but the criminal, you're just saying the criminal court makes the probable cause decision as opposed to the family court?
Yes. So that is the way it has always been.
Is this the art? Well, you're amicus.
Yes,
But I mean, it does seem to me that the district maybe should be actually the party in interest, and the United States should be the amicus. But
Perhaps but
given
we're
the
here-
parents patriae interests in play, but okay,
So
carry on.
So
Thank
what
you.
matters to the district here, and what we think would resolve all of the constitutional concerns, is to simply interpret this statute in the same way that Barnard interpreted 525, because the policy judgment as to which judge gets to decide makes a huge difference to public safety. And that's a judgment that is entitled to respect from this court by the legislature. Criminal courts have historically always been the courts to decide whether someone should be detained after a Jackson finding. Jackson cabined that by saying that you have to at some point start that's only until the civil commitment process is done. And Thomas confirmed that interpretation of Jackson, and the council codified Thomas. And you know, in the council's committee report, when it does its section by section analysis, it doesn't say there's option 1 and option 2, and each one gives process and each one makes a dangerousness finding. It says that the criminal court may continue treatment or release. And then a little further, it says, oh, and subsection B talks about what happens if you release. Right? It's to the council, what mattered was that the criminal court gets to decide. And this makes sense. The criminal court has had this information before it. They've been in many circumstances, they've made probable cause determinations. They've had evidentiary hearings on the facts. Sometimes they have had evidentiary hearings on the person's mental illness. And I get that competency is different from dangerousness, but mental illness is not compartmentalized. You can learn a lot from somebody's psychiatric reports on competency regarding the nature and extent of their mental illness. If a criminal court is uncomfortable releasing someone because the criminal court already knows they're too dangerous to release, the person should not be released so that the family division has 24 hours to familiarize itself with this huge record. And then if there's a procedural problem, if a doctor doesn't show up to testify when the defendant has challenged the facts, that person gets released no matter how dangerous they are.
But I'm sorry, you're talking about the expertise that the criminal court has. The criminal court's heard nothing about dangerousness up until this juncture.
Well,
I guess you're saying this is the point in time, but I don't understand. I mean, the only thing that the criminal court has been interested in is competency.
So this is
up
why
until now.
this is
and
why I'm sorry.
So
I'm sorry.
So is this consistent with what you argued in your brief?
I think so. I think that, I mean, it was all our alternative argument. And it's consistent. We had also added an element of probable cause that the civil commitment, just probable cause to support the civil commitment petition. But I think that's folded into the analysis. Of course, if there's no probable cause to support the civil commitment petition, then there's no reason to hold the person. But
I mean, I'm just looking at your brief. The combination of the commitment petition and the court's prior detention and Jackson findings substantively justify the continued hospitalization. But I just want to make clear that's something that you said in your brief, but that's not what you're arguing now. Now you're arguing the court can have an evidentiary hearing to determine dangerousness, the likelihood of dangerousness to themselves or others, unless hospitalized pursuant to the same standards that would be applied under C2.
I am by no means forfeiting argument 1, but we had an alternative argument there, and that's what I'm pressing this court for today. That's what we think is really the most appropriate course of action, given the concerns. We think that the dangerousness standard—
It's just so funny. I mean, so the district that has a parents patriae interest in people being in the civil commitment system, is saying, don't put this person who hasn't been convicted of a crime through the normal civil commitment system where they would get access to a family court judge. And the government that doesn't have any interest in someone who has mental health problems separate and apart from their criminal case is, I can't make any head or tail of this. This is very interesting.
I
Okay.
apologize if it's confusing. I will note that, we wrote our brief on an emergency basis when this was an emergency, and that there's been a lot of pleading since then that we haven't had an opportunity to respond to. And so if I come to you with clearer thinking before argument, I can assure you that what I am saying before this court, I am authorized to say. It is the position of the Attorney General.
Can I ask you, because I have no criticism, but I'm still hoping to get a direct answer to what you think the Constitution requires by way of a dangerous determination at this juncture.
All right, I'm going to try again for that. Here we go. Okay, so I think that if the statute were written without the word may, I think that if A2 said the court shall detain someone pending civil commitment procedures, I think that would be constitutional under Jackson. And I think so because the United States, that is the civil commitment scheme that the United States has. And this will also, I hope, Judge Easterly, answer your question about the United States interest here, because it's sort of related. So the United States has, even though it has no parents patriae over anyone, it has a civil commitment scheme for people who have been found incompetent to stand trial, for people who have been Jacksoned. And the reason it has the scheme and the reason that it was found reasonable under the necessary and proper clause, or I guess necessary and proper under the necessary and proper clause, is because once the government takes someone into custody, they have a responsibility not to release them if they're dangerous. And none of this is in my brief, but there's case law out there under the IDRA that explains that the reason why this is a permissible interest of the government is because the government shouldn't be releasing people who are dangerous. It has an obligation to the public. So under the IDRA, if a person is found incompetent to stand trial, the hospital has, I believe it's a 30-day window. I'm not sure the exact window. It has a window of time in which the hospital can petition for civil commitment. And if that petition is filed, the release of that person is stayed pending a trial on civil commitment. It's automatically stayed. There is no release. So
That's what the statute says.
Yes. So
Yeah, but no court has upheld.
nope.
that.
As far as I can tell, no one has
Right.
challenged that 2 to 3 month window of time.
And how is it, you leave aside substantive due process, but how is that reasonable under procedural due process? I mean, you would agree that under the federal scheme, maybe 30 days, under our scheme, maybe 2 months, subject to possible, sometimes earlier, sometimes later. That's a quite substantial infringement on somebody's liberty. You agree? I mean, that's quite significant.
And this is why,
I mean,
Well, that's first step. You would agree it's
Sorry.
quite significant impingement or no?
so it's definitely an infringement. I would say that.
Well, would you say it's significant, or you want to defend the proposition that?
No, I would say it's
Sounds
significant. I'm not going to say it's an insignificant deprivation of liberty. Of course it is. And I will say.
And why would it be rational even to impose that without findings that would relate to current need to do it, which would be current dangerousness, current mental health, and current nexus between those two things? Why even under sort of due process Matthews versus Eldridge balancing is it sensible on whatever might have previously been determined, which again are maybe in typically some kind of probable cause determination, but sometimes not, as apparently in this case, as to whether someone has committed the underlying crime. The crime might be dangerous, might not be. So you really don't know too much necessarily about dangerousness of the person based on what's arisen. Competency issues, which could relate to intellectual limitations, could relate to mental illness, could relate to mental illness that is dangerous, might relate to mental illness that doesn't really necessarily raise concerns of dangerousness. Without any of those findings, why even under sort of ordinary Matthews versus Eldridge balancing, is that a reasonable way to treat folks at the end of a Jackson hearing?
So because our statute has the word may in it and implies discretion, I'm not saying that our statute is constitutional without standards. So I want to make that clear. I'm explaining why the
But
question.
I thought you said,
I-
I thought you were saying that if the statute required automatic, essentially said to the trial judge, this is your only option is we're going to have a 60-day or roughly 60-day transition period, that would have been constitutional. And it seems like that implies that there is no need for a case specific determination of dangerousness. And I was just wondering how you would reconcile that position, which I thought you were taking, with kind of a Matthews versus Eldridge assessment of the interest on one side, the risks of error on the other side, the findings that might or might not have been made in any given case. And it seems like a tough position to take.
So the federal courts that have addressed this, which have not addressed Matthews v. Eldridge with regard to this window of time, the mandatory stay. But they have said that the reason why, and the reason why it's rational, and they have talked about that, is because it is supported by a sworn certificate of the hospital that must contain detailed reasons why the person must be committed, because they would be dangerous if they are not. And that holding someone for a couple of months until they get a hearing on that is not a sufficient, that it's rational to hold them for
Well,
that. And
I mean, if you, I think you would agree, I don't know, but is it your view therefore that as a matter of Matthews versus Eldridge balancing, that a state civil commitment regime could say, upon the signing, of a sworn declaration by a qualified doctor that a person should be civilly committed under a dangerousness standard, the person may be taken into custody, given inpatient treatment for 30 days or 60 days without any further process. And then at 30 days or 60 days down the road, a judicial officer would determine whether that was warranted or not. Would you think that'd be a lawful regime?
no, and the reason why, and there's very little case law on this, but the reason why is because the person is already in custody. And so I'm going to refer you to actually Mr. Peyton's reconciling of strict scrutiny versus the rationally related standard that's in Jackson. So the way Mr. Peyton, the framework Mr. Peyton puts forward is that you need strict scrutiny to take someone into custody. And that is the least restrictive alternative standard. You need that. But that for how long they're going to continue to be held in custody, it just needs to be rationally related to the purpose of being held in custody. And Jackson said that during the period of time between civil commitment being, the hearing on civil commitment and the Jackson finding, that's an intermediate amount of time and that it's rationally related. But Your Honor, I do not want to be, I'm telling you what I think the standard might be. There's no case law on this, and we are not defending this law on the grounds that no hearing is required. We think that the hearing is required, and I really want to go through why we think this interpretation is consistent with the statute, because this is what Mr. Peyton has said, and frankly, we haven't had an opportunity to respond to this yet, because this was in response to our amicus brief. So first of all, what the court did in Barnard is it established a substantive standard, which was probable cause. Then it established a whole host of procedures that would satisfy probable cause. It said the doctors don't need to appear live if the person being held is not challenging the facts or the diagnosis. We think the same thing here. And we think that's one of the reasons why all that's required is a status hearing unless someone asks to introduce evidence. There's nothing in the word status hearing that precludes a court from hearing evidence. And I want to refer this court to INRE HB. This is not in my brief, so I'm going to give you the citation. 855 Atlantic 2nd, 1091. And in that case, involving a deprivation of what was clearly a liberty interest because it was a mother challenging someone else adopting her child, the court held a status hearing because it had stayed matters to see what new events transpired. It wasn't comfortable making a decision earlier, held a status hearing, put the mother under oath, took testimony, made credibility determinations. Mr. Peyton has offered no authority suggesting that the words status hearing were somehow meant to preclude the hearing of evidence. And I would proffer that the reason why it's a status is because evidence might not need to be taken if the defendant isn't challenging the facts underlying the civil commitment petition, which would be those facts would be what are at issue in this hearing. I also want to talk about, so I've talked about status, I've talked about the word may, which the case Zadvitas says does not imply unlimited discretion. And Zadvitas has added in itself, it added not substantive standards, but time-related standards of reasonableness to may. Obviously, Connolly, this court has already pointed out, is quite different, but I would like to point something else out about Connolly. In Connolly, the Supreme Court said it would have stayed the statute if all it had to do was adjust the burden of proof or the standard that has to be established. The reason why it couldn't save the statute is because the statute was unambiguously made it criminal to be in a car with a gun, and that itself was unconstitutional and could not, there's no way to take a non-ambiguous provision. But the court said it would have been willing to save the statute otherwise. Tilly also is entirely based on unambiguous language, and that's why the court couldn't attempt to save the statute. What happened in Tilly is that essentially the statute was authorizing unlimited detention of someone for their criminal actions without a finding of mental illness or mental impairment or one of those special features that takes it outside of the realm of the criminal process. And the reason why the court couldn't read that into it is because the SPA, the statute there, required the lack of control, which was the impairment that it was apparently based on, to be found from repeated misconduct, which is no different from somebody who's just a repeat offender. The court couldn't read those words out of the statute because they were unambiguous. And so the court could not save that statute. So I think what this court needs to do is look at Barnard and follow the standards there. If a court looks at Johnson, and there's two 1997 Johnson cases, so this is the one that starts with 699 Atlantic 2nd. In that, it had to do with a liberty interest that was implicated by being subpoenaed for a psychiatric evaluation. This is from a private commitment statute, a commitment petition. And that statute didn't provide for any process at all. It didn't even provide for a hearing. And yet this court said that the probable cause is the standard, that someone could challenge probable cause for civil commitment, that they could seek an evidentiary hearing if they were challenging some of the facts, and that the trial court had the discretion to determine the scope of the hearing consistent with constitutional principles. That's all we're asking the court to do here. And I will also note that Thomas itself essentially saved a statute. It read Jackson into what existed before, which just allowed the criminal court to hold a defendant indefinitely after they were found incompetent. And it added a 30-day limitation that was later codified, but that wasn't codified until like 15 years later. Until then, the statute existed with the modifications that the court had I don't want to say saved or read into it because apparently those words aren't working anymore. But what we're saying is that because A2 says that the court may hold someone, and there's even language in 06C4 that is referring to the A2 hearing. Why that's in 06C4 and not in A2, who knows, but also refers to as is necessary, which can be read as a standard, that this court can easily interpret this statute as requiring a finding of probable cause of dangerousness with or without evidence, depending on whether the defendant is challenging the substantive findings. And of course, referring to Thomas, which sets forth the standard that the person would be dangerous to himself or others if released. I apologize, court's indulgence. I just want to make sure I've gone through my list.
So the statute can be saved, to use dangerous language, because A2 says may order treatment to be continued.
Yes. Yes, I mean, that implies the application of discretion. And we know that once a court has discretion, it has to be.
Do you think that, sorry, the statute says may either order the treatment be continued until the entry of final order in the civil commitment case or release the defendant from treatment. So are you saying that the may or may not order treatment to be continued until the entry of a final order in the civil commitment case?
Yes, I think that's the may, the either. And actually, this leads me to where Mr.
Isn't it written in a way that suggests that the court has two choices: either order treatment to be continued until the entry of a final order in the civil commitment case, or release the defendant from treatment. And if it's the former, the statute gives no guidance.
I mean, I think it's correct that the statute gives no guidance, but that doesn't mean that the guidance can't be implied. Lots of statutes say may without indicating what the standard is, and this court has had no hesitation.
But couldn't you just read it as you can just order treatment to be continued? You just have that power. But I have a child. The child says, what can I have for dessert? And I say, you may have a cookie or a piece of cake, right? You can do one or those two things. So, and I'm not saying you may have a cookie if you turn around 3 times and, jump up in the air. You may have the cookie, right? So this statute says you may order treatment be continued until the until the entry of a final order in the civil commitment case.
Well, and this is one of the
Courts
ways.
do that.
This is one of the ways in which statutory interpretation is different from our common parlance. The courts have held repeatedly that the word may does not suggest unambiguous or unlimited discretion. That's what Zadvitas says. It says may is ambiguous, but that it does not suggest unlimited discretion. You don't have to read it that way. And we think that would be an unreasonable reading. Of course, the court can't just do this on a whim. That doesn't make any sense. It doesn't make any sense under Thomas, which talks about the person being dangerous to themselves or others if released. It doesn't make any sense from a liberty interest point of view, because as I said, I have a position that I think the law would be constitutional because I think the IDRA is constitutional, but we don't have any case law on that. If the court has concerns about the constitutionality of A2, then the court should save A2 or interpret A2 to include the constitutional requirements that would support the council's policy judgment that the criminal division should make the first call, or at least has the right to hold someone if they already know that someone is dangerous. Why would they pass that off to a different judge who
Why
hasn't had the
wouldn't we
time?
interpret that legislative history to be, well, if the criminal court wants to hold the person, they can. Full stop, period. If they don't have a position on it, they can release the person to the inpatient treatment facility, let them make the call. It's nothing, doesn't matter to the trial court.
Well-
But that, why not interpret the statute to say, just as it says, look, trial court, we give you total power, hold this person if you want to.
In TGV Carver, this court said, the cardinal principle of statutory construction is to save and not to destroy. If we interpret the word may as providing unlimited discretion, then that would make that provision unconstitutional and the court would strike it and it would destroy it. And that's just not the cardinal principle of statutory construction. Zadvitas says that a statute should be saved if fairly possible. And it is certainly fairly possible to read into the word may that there's some standard that needs to be satisfied. And again, if this court adopts the interpretation the district is proposing here, which is to just follow what Barnard did for the 525 hearing, if this court adopts that interpretation, the only difference between the two statutes or the two options is who decides and on what timeline.
Well, but I just want to walk through. So you're saying the court may either order treatment be continued until the entry of a final order in the civil commitment case or not. Right. So say I'm the criminal court judge and I decide I'm not going to order, then is that order not to enter to order treatment until the entry of a final order in the civil commitment case? Does that constitute a release such that I go to C1? Or is that just I'm not ordering treatment and we're done here? Where do we go?
Okay, so it's either order continued treatment or release, and that's consistent with the Constitution.
No, I just thought we had a conversation where you said there's the may suggests this permissiveness of you can order treatment or not, separate and apart from the release decision. Did I misunderstand?
Yes, or maybe I misspoke, but the or not is the or release, that it's the same thing. And I want to respond to what Mr. Payton's counsel
Then I'm
said.
just back to my cookie example. I gave you two choices, cookie or cake. Which do you want? And there's no predicate showing or anything that you have to do it. We're just empowering, the council is empowering the trial court in this case to order treatment to be continued until the entry of a final order in the civil commitment case.
Well, I think it's clear.
I thought you were saying may means there's discretion within that decision. And so then we know that, we can import these constitutional principles and maybe part of C1 but maybe I'm not following along.
Well, and this interpretation and maybe I'm misunderstanding, but this interpretation that I'm hearing you propose is not one that's been proffered in this case. So
Well, no, it's built off of what I thought counsel for Mr. Payton was saying, which is that wouldn't make any sense to have a trial judge do the discretionary determination under A2 pursuant to a probable cause determination or a preponderance of evidence determination. And then if the court decides not to continue treatment until the entry of a final order in the civil commitment case, release them to inpatient custody, get to C1, and then they have the right to the hearing under C2. That doesn't make any sense. That's not how you should read the statute. That's what I heard them saying. So no one is advocating for that, but it seems like the I thought I heard you say this is a possible interpretation, which would walk us into this sort of absurdity understanding, which I think also Judge McLeese raised, but.
Okay, and I appreciate that. I think we're on the same page now, and this is actually where I wanted to go when I was talking about what Mr. Peyton's counsel proposed at the beginning of his argument, which also wasn't in any of the briefings, so we're sort of shooting from the hip here. But I think that he presented a false dichotomy, that the judge either has to make findings that the person is too dangerous to release or is not dangerous. And that's not really what the district is proposing as an interpretation, that the judge is making if the judge makes a finding that the person is too dangerous to release, then the judge can hold the person, or the judge can just say, I don't have a position on this. I don't know whether
But what about it? I get your point that a judge could say, I don't really feel like I'm the person to decide. So I'm not going to assert the authority under A2 to be the one to decide. And instead, I'm going to release and let the family court sort it all out. So then you wouldn't have the conflicting absurdity that Mr. Gunnar mentioned. But imagine a case where the trial court says, I'm going to make the determination. And I've now found that there is not probable cause to believe this person is dangerous. Therefore, I'm going to release this person I'm going to release this person to treatment, which then sends you down the Macklin Road. And the first thing that happens is then that person is detained anyway, briefly, even though the trial court has said, right, before the decision to say, yes, I'm going to send you off to the Macklin Road. I'm going to make a finding that's inconsistent with continued detention under the Macklin Road. And then the defendant come in within 24 hours on the Macklin side of the road and say, oh, by the way, I'd like to contest whether there's probable cause to believe I'm dangerous. And by the way, the trial court just decided that, 18 hours ago. That seems like a funny structure. And what's your response to the idea that could create some problems, and one could say is inferably not what the legislature had in mind?
I guess my initial, just to preface this, is that we're defending the facial constitutionality of statutes. The fact that some judge might do something really wacky is not a reason to strike the law.
I think you're doing more than that. I think you are arguing that the statute could be interpreted to avoid some constitutional issues. But there's nothing wacky about the hypothetical I gave. I mean, at the first part of it, a trial judge could quite well think, you're right, I'm the one who sat through this. I am really a good person to decide this. I'm going to have a hearing. I have had the hearing and I determined there's no probable cause to believe that the person is dangerous, and therefore I'm not going to order inpatient treatment in the criminal case. Well, then the statute requires the other half of the or is not I can release the person, but instead I have to release the person to treatment. Then you go down the Macklin Road and the person goes, notwithstanding that ruling, the person remains in a mental health facility. Again, in the typical situation where someone is previously detained, or more complications in other settings. And then, so there's nothing weird about any of that. That's what the statute seems to require in your view. And then it just seems like it puts, it's an odd outcome in the short run for the defendant. And it raises questions about what the proper function of that next hearing would be, because a judge just decided that. So why should the family court judge, I don't know what you contemplate. Do you think the family court judge would have to say, well, that's kind of res judicata, it's already been decided, so I'm going to release the person immediately without having a hearing? Or do you think, it's in the nature of kind of, not law of the case. And so the judge could say, well, I understand, the family court judge could say, well, I understand that the criminal judge just found 18 hours ago that this defendant was not dangerous, but I disagree. I find the person is dangerous. And we head off down the rest of the Macklin Road. That seems like a there's nothing wacky about any of that, other than it seems like it is a funny disposition of it seems like it's a troubling disposition of the defendant in the short run.
So
And it raises questions about what the trial court should do, the family court judge should do in the slightly longer run.
So I have a few responses to that. The first is that remanding someone to DBH does not mean that DBH is necessarily going to hold them. DBH then can release them if DBH does not think that they're too dangerous. So that's the first line of defense. And my second thought is that probably the family court would be swayed by the trial court's decision, but the family court might not be, because it's possible that the district in that scenario didn't put on any evidence beyond the civil commitment petition and then put on different evidence. But here's, I think, the reason why the court need not worry about that. So there's two hearings where the criminal court has an option to release the defendant, right? There's the hearing before the civil commitment, the Jackson finding hearing, right? Before the 30 days for the district to file a petition for civil commitment.
This is the 06C4 determination.
06C4 determination. In that hearing, the judge can find that it's not appropriate to hold the defendant. And I agree.
Based on what?
I'm going to take the same position as the United States. This is not something I've looked at, and I'm certainly not authorized to stand.
Right, but you're bringing it up as if it's some reassurance.
I'm
So
not constitutionally. Not. I promise I'm not. So I'm just saying, in that scenario, if the judge made findings and said, I find that you are not dangerous, that you pose no danger to society, and I'm going to release you, DBH could FD12 the person and start an emergency hospitalization.
Just to follow you on that, I promise I'm not relying on it. Like, the issue is that as you read C4, the court could make no findings, right? No findings are required. The court could just say, I'm holding you for no particular reason at all, right?
Well,
so that's the scenario that I'd like you to think about. So the court has just said unthinkingly, you're being held 30 days. We'll see if they file a civil commitment petition, come back. What do you know? They did. Now we've got a statute that says, well, court, once again, unthinkingly, you can continue treatment, right? Until the end. Or if you want, you can release the defendant from treatment, let DBH worry about this and give this person a little bit of process.
So I'm going to tell you what I can about C4, but then I really want to turn to Judge McLeese's question about, because I'm not sure I've satisfied that. As to whether, I do think there is a standard that must be implied under C4 for the same reason I think there must be a standard for A2, because under C4, it says if appropriate, and if appropriate implies that there is some standard. I do not think the question of what standard that is before this court. I certainly don't have authorization to take a position on that here. But I was offering that as an example to say that you can always initiate emergency hospitalization. And that's actually what option 2 is under the holdover provision, that A2 says either you.
Well, it's not entirely emergency hospitalization. That was the issue in In re Macklin.
But
And the court said it sort of drops you into the middle of emergency hospitalization.
Exactly, because the first parts. I know, I do not want to relitigate Macklin.
No,
I will leave that aside and just tell this court that if it is concerned that there would be some sort of conflict or double negative, if it's describing the procedures, it should say that if the court finds the person to be dangerous, that it can hold them. And if it does not have a determination, the court could write a decision that resolves that, or it could deal with that on an as-applied basis. But it's not a reason. The fact that something like that could happen is not a reason to facially strike a statute, especially when that situation hasn't been presented in this case, hasn't been briefed. None of us are prepared for that particular question. What I'm saying is this statute can be saved if fairly possible. This court in Sharps still applies the standard for Salerno that if there is a constitutional application for a statute, it's facially valid. So for that reason, because of course there is a constitutional application, all this court needs to do is take a close look at Barnard, follow those standards. It can go as far as it wants. It could just find the probable cause is necessary and not get into procedures, leave that up to the courts like this court did in Johnson, or it could do what it did in Barnard.
Leave it up to the trial courts?
Yes, that's what Johnson did. Johnson said the trial court can determine the scope of the hearing. It said that there has to be a probable cause standard. So there's two different roadmaps for this court. But I think that that what would really be disrespectful to the law and the policy judgment of the council is to take this out of the hands of the criminal court. And that's where the district is, that's why we're here.
Why would it be disrespectful to the legislature to just throw it back to them and say, why don't you fix it?
Because we don't think there's a problem to be fixed.
I thought
And-
you were just telling us to read a whole bunch of stuff in. I mean, I'm just putting my cards on the table, but it seems like you're asking for a whole lot of judicial activism, either by this court or by trial judges. And the simplest thing would be to say, oh, this is a problem under modern constitutional law.
See,
and counsel, be our guest.
I would argue that striking a statute instead of saving it when saving it is fairly possible and consistent with what this court has done in the past with similar statutes, that would be judicial activism, because that would be deciding that only the family court gets to decide this and that the criminal court doesn't get to decide it. And then in the window of time before the legislature can get their act together and pass a law, I mean, who knows what's going to happen there? The point is that this court has consistently throughout history, as long as this court's been in existence, saved laws instead of destroying them. And so that is that is the role of this court. And that's what we're asking this court to do.
Thank you, Ms.
Thank you.
Johnson. We kept you up here quite a long time, so we'll let you
You
sit
might
down.
win the prize.
Mr. Gonen, we will try very hard to give you 5 minutes.
Okay. The District of Columbia says it wants to save this statute. I think it's clear from what everyone has said today, that's not going to happen, because whatever this court holds, it's not going to be the statute that was written. It's going to be a Frankenstein statute. It's going to be little bits of A2, little bits of 525, little bits of case law distilled into a statutory form. It's not going to be the statute that was written by the legislature. That's beyond saving, I think, as even my colleagues on the other side would agree. Nobody is saying that A2 as written can be constitutionally applied. I want to just begin by addressing HB. HB is a case that Ms. Johnson brought up. I did read it quickly. It does say the court held a status hearing and it heard evidence at the status hearing. My understanding of that case is that's saying that if a judge schedules a status hearing and the parties come in and want to put on evidence and nobody complains, this isn't fair, we thought it was a status hearing, the judge can hear evidence. And that's quite different from a statute that specifies a status hearing. That's very unusual. I can't really think off the top of my head of another statute that specifies it has to be a status hearing as opposed to just a hearing of some sort or an evidentiary hearing. I want to talk about Thomas. Thomas is unambiguously, expressly an equal protection case. The only time the words due process appear in the Thomas opinion are to say that because we're in the District of Columbia, equal protection arises under the Fifth Amendment due process clause. Not only does it not use the words due process, it doesn't use anything that resembles a due process standard. It doesn't say compelling interest, narrowly tailored. It also doesn't have the benefit of what we think the four most important due process cases in this context are Salerno, Zinnerman, Fuchsia v. Louisiana, and Reno v. Flores. Those all post-dated. So
It doesn't really seem like an equal protection case, though, except that it says it is.
well, let me explain why it is an equal protection case, because Thomas says, look, there's three ways you can be involuntarily hospitalized. You can be civilly committed, you can be emergently hospitalized under the Irvin Act, and then you can be Jacksoned. And then it says, okay, well, the Jackson people are not like the civil commitment folks, because this is not indefinite commitment and it's temporary. It's only during the duration of the civil commitment proceeding, so lesser procedural safeguards are appropriate. So in terms of similarly situated, we're not going to look at civil commitment under the Urban Act. That's not the right comparison group. Then it says, okay, under the emergency hospitalization under the Urban Act, they say at this hearing, the hospital or the petitioner need not produce testimony, but may rely on the papers unless the patient offers evidence which sufficiently rebuts the documentary evidence, citing Barnard, which I'll come back to. So that's and I view that citation to Barnard as descriptive. It's describing, it's understanding what happens in the 525 hearings, as opposed to holding that is what the Constitution requires as a matter of due process, which would be a weird thing for it to do without saying so. And then it says, okay, here's what Mr. Thomas got. Mr. Thomas got a review of the papers, including papers talking about his mental illness, talking about his dangerousness due to mental illness, talking about the need to keep him in the hospital, because according to the opinion of a psychologist, he would do things like throw a baby out of a window, again, if he were not hospitalized due to his mental illness. And the judge essentially says, I would be remiss if I let him out. So it's essentially a dangerousness finding. So the holding of Thomas is people like Mr. Thomas are similarly situated to emergency hospitalized patients. Therefore, under equal protection, they should get the same procedures or materially the same procedures. And that's what Mr. Thomas got. Now I want to talk about Barnard, which is a non-binding DC Circuit case that is a Fourth Amendment case. So it's applying what does the Fourth Amendment require in terms of holding somebody at a 525 hearing. It's a little bit more expansive than what Thomas says. It says you get live testimony from the doctor is required if counsel for the patient makes a proffer of contrary proof or challenges the accuracy of the facts or diagnoses in the papers. It says mere conclusionary statements in the papers aren't enough. It has to have sufficiently detailed, be supported by facts to allow the judge to pass on the credibility, right? So the judge has to make a credibility assessment. And it says even if the government can rely on the papers, the patient can subpoena the doctor. So the patient can force the doctor to testify and cross-examine him about his opinions and conclusions. Since Thomas and Barnard were decided, we had the court's en banc decision in Herman, which is cited in at least some of the briefs. And it describes the 525 hearing as a full, quote unquote, full evidentiary hearing. And that is in fact how it works today. As it works today, there's always live testimony. I don't, at least as far as the Public Defender Service is aware, and we're assigned in all these cases, so we would know. Herman also says, the entire statutory scheme postulates independent judicial review as the cornerstone of the protections against erroneous deprivations of liberty. Such review is at the heart of due process. So, right. So we're not just going to say a doctor says he's dangerous. I'm going to rubber stamp that. It has to be a full blown hearing.
I thought part of the reliance on Barnard, and I was trying to pull it up, was on the question of facial invalidity and the freedom of courts to deal with constitutional problems short of facial invalidity, and suggesting that some of the statutory provisions that were being interpreted in Barnard and that are still applicable on the civil commitment side really are lacking in any detail about how things are going to be done. And the court just, pick your phrase, read into, right, saved, provided what the Constitution would require. And so I'm interested in your addressing that aspect of their reliance on Barnard and other cases that they assert reflect a similar perception of a freedom of authority to deal with these issues short of facial invalidity.
Sure. So everybody knows that legislatures legislate against a background of sort of legal principles. So it's not uncommon for a statute to say there's got to be a hearing without specifying, who presents evidence first, who presents evidence second, what is the burden of proof? Because there's a tradition of legislatures expecting courts to read in kind of based on background legal principles. So it's not making it up. For example, in the compassionate release statute, it doesn't specify a burden of proof. So this court said, well, we kind of default, there's a default burden of proof. And as a legal principle, we understand that when a legislature doesn't specify a specific burden of proof, we're going to read the default burden of proof in there. So that's kind of like consistent.
Didn't Moore go on? I mean, I'm just looking at 21-525, which talks about the hearing by the court. It just says the court will have a hearing. It doesn't say anything about what's going to happen at that hearing. It's not just, it doesn't say burden of proof. It's not just, it doesn't say what the procedures are going to be. It also doesn't say what substantively is to be determined at the hearing. And I thought that Barnard and perhaps also the en banc decision in Herman ended up, pick your term again, interpolating, reading in, saving by providing substantive requirements about what needed to be shown in such a hearing.
Right. Well, Barnard, which is not controlling, and let's put that aside. Let's look at Herman. Herman says, okay, you get a 21-524 hearing, which is expressly based on the papers plus other relevant information. It's often described as an ex parte hearing, but the statute doesn't actually say ex parte, and there's really no reason why the patient couldn't submit their own medical report saying, hey, I have a psychiatrist who's been treating me for years. He says I'm not dangerous. And the court would have to consider that at the 524 hearing because it says it has to consider other relevant information. But that's clearly, Herman says, okay, well, that's a hearing on the papers. So then 21-525 can't just be a repeat of that because that's already happened. So it has to be a full evidentiary hearing, and that's what the phrase it uses. It doesn't necessarily specify everything that means.
Or the substantive issues that need to be determined at that hearing?
Or the
statute to be lawful?
Well, it has to be, yeah, I guess that's right. I mean, that's true, but at least it's saying.
Seems like, and your opponent's argument, I think, is the motive analysis that you're suggesting would suggest that whether Barnard is binding on us or not, which I think it's not, but it suggests that if a similar challenge was brought to 21-525, the answer would have to be, just really doesn't tell us what we need to know, and it's beyond our judicial function to do more than, and there are limited things we can do, but providing substantive standards and the like is kind of outside ways of addressing problems like this. I think that's the gist of their point.
But it's not the same at all, because both 524 and 525, there's been a petition filed, and the allegation of the petition is that this person is dangerous due to mental illness and therefore needs to be detained right now. And that's what the court is deciding. So there is a substantive standard. It's what's alleged in the petition. In our context, we have a civil commitment petition, which doesn't even allege that the person needs to be detained, hospitalized right now. It alleges that if they are not committed at some point in the future, then they would be a danger to themselves or others. And we've all agreed that there's an important difference in those two standards, and that there are actually, I think, 30 to 40 people a year who have civil commitment petitions filed against them and are not emergently hospitalized. So this is like a significant number of people who may be subject to civil commitment, but don't need to be hospitalized prior to the completion of that process.
But I mean, just to be clear, I mean, it goes beyond just like the civil commitment petition is sort of directed at something else other than imminent dangerousness, right? I mean, A2 doesn't say you get a hearing on this decision of whether or not the trial court keeps you in treatment,
right?
Or whether the court releases you. It doesn't say you get a hearing on that.
Correct. It says you get a status hearing to determine if a petition has been filed.
Right.
And that's it. That's the problem. And this is why I'm saying you can't save the statute. You could, we don't think it would be consistent with Tilly, but the court, could issue an opinion saying everything this statute says is wrong, but we're not going to say it's unconstitutional. We're instead going to say all the things that it should have said. But that's why I went back to what I said at the beginning. That's not saving the statute. That's not, if the will of the council was, as Ms. Johnson said, to codify Thomas, which is not a due process case, which was decided before the key due process precedents, well, then that will of the legislature cannot be allowed to stand because it's not constitutional under due process standards. I think everybody agrees with that.
A part of Ms. Johnson's point, I thought, was that at least an aspect of what she argues is the legislative purpose could be retained. If part of the purpose is to give the criminal judge the opportunity to decide these issues rather than sending them off in the first instance to the family court. So
right. Well, there's
that I thought.
Yeah, I think there's a pretty easily solution to that which is like, let's not forget that these are all Superior Court judges on the same court. They rotate calendar assignments. If the criminal court judge were to say, there needs to be, I need to release and remand you because I can't continue order treatment without having hearing, and I'm not allowed to have an evidentiary hearing because it's only status hearing, whatever. But I just know so much about this case. I've read all these papers. I'm really familiar with your diagnosis. I'm going to ask the mental health court judge to certify the probable cause hearing to me. And then I, with all my expertise, will be the one to make that finding. There's absolutely nothing wrong with that. And it doesn't violate any statute, doesn't violate anything. I mean, these calendar assignments are completely discretionary at the chief judge's will. So if it's just a matter of which judge we want a particular judge with expertise to decide this, fine. I mean, there's no guarantee that the criminal court judge is going to be the same judge who made the Jackson finding. It could be, in this case, Judge Krauthammer was the judge who made the Jackson finding and the A2 finding, but at the next hearing, we were in front of a different judge, and some of these misdemeanor calendars, the judges are constantly rotating. So there's no guarantee you're going to get a judge on the criminal court calendar without any expertise. So if that's the issue, fine, let the criminal court judge make the finding. That's not a problem. I I do want to emphasize, Jackson does have an equal protection holding in addition to its due process holding. And the equal protection holding of Jackson is that the existence of criminal charges do not justify treating Mr. Jackson any different from any other civil committee. And in this case, that means that the fact that Mr. Peyton has pending criminal charges or had pending criminal charges is not a basis to treat him differently from anybody else who is subject to civil commitment. And anybody else who's subject to civil commitment can't be detained unless they get a hearing, the constitutional minimum of a hearing on dangerousness. I just wanted to address briefly something Mr. McGovern said about Tilly, which is, Tilly did have this issue that the DC Circuit in a case called Millard had interpreted insane or not insane in a very broad way that basically meant the Sexual Psychopath Act could only be applied in an unconstitutional way to people who didn't have any kind of mental abnormality. So Mr. McGovern is right about that, but the key part of the Tilly opinion is they say, even if we overruled Millard, that wouldn't solve the problem. The problem here is that the bigger substantive due process problem is that the statute does not require a finding of mental abnormality tied to the future, violations of sexual assault laws. Without a requirement that finding be made, the statute is unconstitutional in every application. And I also do want to point out that I think if the court were to interpret the statute in the way that the governments are asking it to, it also would be unconstitutional. Maybe not in every application, but certainly every time a judge said, I don't find you dangerous by whatever the standard the court adopts is, it would be required to order an unconstitutional period of detention. Once the judge has made the finding, you're not dangerous, the only constitutional option is to release them. But the statute would say, well, actually, even though I'm constitutionally required to release you, the statute says I have to remand you to St. Elizabeth's and you're going to be held for at least another 24 hours before you can get a hearing at which a judge would be empowered to release you. Now, let me say this. I think on behalf of Mr. Peyton and other people who are subject to these statutes, I think we would be quite happy if the court said under A2, a judge has to make a finding under a preponderance standard, as the U.S. Attorney's Office says, that the person is dangerous. And if the judge makes a finding at that A2 hearing with a full evidentiary hearing that the person is not dangerous, they are empowered to order not just release and remand, but physical discharge, immediate physical discharge from St. Elizabeth's. I don't think we would have a problem with that statute. And if the court were to reach that conclusion, I think we would all be very happy with it. To be perfectly frank, it's not consistent with the position we've taken on the appropriate function of the judicial role in interpreting statutes, but the government has set its preponderance standard. I don't think a judge who finds lack of dangerousness by preponderance could constitutionally do anything but order physical discharge from the hospital. So if that were to happen, that would be constitutional. And I'll leave it at that.
Okay.
Thank you.
Thank you very much, Mr. Godin. Thanks to all of you for your briefing and your arguments today, and those of you in the audience for your indulgence. We will take the case under advisement and we are adjourned.
All right.